Good afternoon, and thank you for joining. I'm Daniel Jastrun. I'm Polish attorney and the founder of Jastrun. Jastrun is a boutique law firm located in Warsaw. We work a lot with technology and data, so our focus is law related to tech and data, and also M&A transactions. So personally, I work a lot with corporate M&A. So I have a pleasure of working for investors wanting to invest in different startups, but as well, quite often we work with funders and help them in discussions with the potential investors. So I could see a lot of mistakes or omissions. So I can say from the experience that it is quite important to be well prepared and to think about some issues already at the beginning, because later it may be a little bit too late. One point couldn't be clearer, that legal know-how is critical for startups, and tackling legal and compliance issues early is a growth enabler. So you should treat the compliance as a tool to be even more have a competition advantage compared to companies which are not thinking that much about compliance or legal compliance and compliance in general. Especially, I would say in Sweden, which this market is quite sensitive regarding the compliance. So avoiding risk saves the time and money later. So to start with, first you need to, if you want to scale up, you need to pick up a right company form. So meaning that in case of thinking about scaling up, about letting the investors coming in, okay. So you need to have a capital company, meaning in case of Sweden it will be aktiebolag, in case of Poland it will be limited liability company or joint stock company. Of course, as a startup, you can start as a partnership, but as soon as you want to scale up, you need to have a form which allows the investor to buy shares, to invest into the company. Next step, and first step, you should start with sitting together with the people you are doing the business, together with your partners, and discuss. It was already mentioned by speakers before me, to align, to think what you want and where you want to be, not within 6 months, but maybe as well within 3 years or 5 years. Therefore, the founders agreement or shareholders agreement is really crucial, because in this document you can describe what will happen if your visions in the future will split apart. You know, the life is running, time flies, and you may be 3 of you, 4 of you. Now, today you have the same vision, but after some time, one of you may have some family issues and decides that no longer he's able to participate, etc. So it's very important to think about this. And moreover, whatever you agree between you, like from business-wise, it will be quite easy for lawyers to translate into legal language. Like limited liability company gives a lot of flexibility regarding how to structure and how to avoid the deadlock situations. There's like several of clauses which typically are in this kind of agreements. One of the situations which you should think about is what if within 3 years we want to scale up and invite the investor, and a minority shareholder says no, I don't want to have an investor. It's why it's so crucial to have in the agreement so-called drag along clauses or tag along clauses, making it possible for drag-along clause, it is the provision that allows the majority shareholders to force a minority shareholder to sell the shares on the same conditions as the majority shareholders are selling to the potential investor. And similar with the tag-along right, it is the clause saying protecting the minority shareholder and giving him the right to demand that if the majority shareholder is selling the shares, so the minority shareholder can sell on the same terms and conditions. Quite often you also have transfer restrictions or ROF, right of first refusal, or the clauses which say that if any shareholders wants to sell the shares, it needs to sell it first, propose the sale to the remaining shareholders. So it's important to try to keep and think about it at the very beginning, because as soon as you success and the big monies are in play, then it is more difficult to have a settlement. At the very beginning, it's much easier to think about how it will look like. So it's quite important to have an order in place at the very beginning. It's also important to keep the okay. It's like short. Oh, okay. I didn't mention it. It's also one. For instance, if you have two shareholders with a similar votes, you need to have some solutions to what will happen if you start disagree. And one of possible solutions is like to include a so-called shotgun clause in the agreement. It works in the way that partner A may propose a price, and partner B needs to either accept the price and sell its shares to partner A for this price, or may demand that the partner A buys the shares for that price. It's like good, quite aggressive, but interesting way of because in case of startups, it's very difficult to evaluate the shares, and this helps to avoid a deadlock situation. So it's quite important to think ahead and have good funders and shareholders agreement from the beginning. But what is most important is like to secure the full rights to IP. The main value in case of most of the startups, it is IP rights which you develop. Usually software, but it can also be an idea or trade or patents or trade secrets. So if you are in the software business, it's really crucial to have from very beginning to have agreements with software developers which are developing the system for you, especially in Poland, where it is quite popular with B2B agreements, meaning that in case of startups, I would say 95% of software developers will cooperate as a freelancers. And if you have this kind of cooperation, then there's no automatic transfer of IP rights. You need to have a written agreement. Again, in Sweden, not necessary, but in Poland, it needs to be written. So you need to have a wet signature or qualified electronic signature under that. And you need to have a special clause in the agreement saying that all IP rights are transferred, and even you should also list fields of exploitation. So it is quite formalistic. If you don't do it, you have license, but there is no IP rights transfer. And investor may come and say, okay, you have great product, great app, but you don't have rights to it. So think about IP from the very beginning, because it's the main value in your company. Last issue, okay, next issue is of course taxes. So think about taxes and be tax compliance, because it is what came up during the due diligence, and it is what the investor will require, is to have a reps and representations that everything is okay with the taxes. So have a good accountant from the beginning and try to be transparent and diligent. And last issue, very important, is the compliance, mainly GDPR, which applies to almost everybody. But there is really a lot, and it is more and more. Each day, or maybe not day, but a lot of these acts are very new one. So I would say that European Union is like thinking about keeping the lawyers busy. AI is taking our job slowly, but regulator is and of course, as a startup, you cannot have all the rules in place as you would have in the case of big corporation, because it would kill your business. But you need to be aware, and you need to think and to design the products in the way that is compliant with the law and with regulations. So, for instance, if you have an application which I don't know, do something with the personal data, it's not only about legal, but the IT structure and the system needs to. You need to have a feature which enables you to let's say distract the personal data if the data object, if the people who ask for this data, you need to have to be able to extract it automatically. You will not be able to do it manually. So really, like it's when the law needs to be reflected in the system, in the IT. And most important are probably GDPR, a new one, AI Act, because everything is now about AI, and Data Act. But if you are in fintech sector, it will be also NIS2, DORA, etc. So probably most of this will not apply to you in particular, but you need to check it, and you need to think at the very beginning to make a business compliant with that. So yes, I think we are. So okay. So of course, mind the differences, also the cultural differences. What's positive about this list of EU regulations and compliance? Okay, it's a lot to think about. But what is positive, that it is EU-driven, meaning that if you are compliant in Sweden, so 99% will also apply in all other European markets. So it makes it a little bit easier. So quick takeaways. So choose and register the right entity, formalize the ownership, think about your relations with co-founders, secure IP and data, get ready for investors. So don't have a mess, document everything, keep the agreements, keep the board resolutions, think about that from the very beginning, even if at very early stage you may think it is not necessary. Mind the tax law, mind the employment laws, and mind the compliance. So, as we say, prevention is cheaper than the cure, so think about that in advance. And of course, in case of any questions, just I will be here and happy to answer it. And please also feel free to contact me later on LinkedIn or by email. Thank you.
Thank you so much, Daniel. I have a question for you as well. Since there are many startups here, and sometimes when it comes to legal issues, you have a tendency to, since I'm your friend, I can say this, lawyers are expensive. And sometimes when you look at this as a startup company, you go, oh my God, I'm going to have to invest hours and thousands of Swedish crowns or Polish zlotys into getting assistance from you. How much is it, to be honest, in the beginning? I mean, if I just make the minimum effort, I mean, how much would it take for you to help me just get started with a shareholder agreement? And, you know, are we talking weeks or months or?
I think I would say it depends a lot, and also like prices are quite different in case of legal services in Sweden and in Poland. As I said, you will not be, you don't have to be to introduce all the possible procedures at the very beginning, but you need to be aware. So I would say it's worth to consult a lawyer. For sure, if I would choose one thing, if you want to keep a budget and just consult one thing, I would go for IP transfers. It's most important. In our case, I think it's quite reasonable because we are also kind of boutique law firm, and I would also say that I think also this legal market, I already mentioned, it will be changing due to AI. So we are now using more and more also AI tools, making our work quicker. So I think the legal market will also change, and hopefully startups will get more results for less.
We appreciate that. Thank you so much.